Welcome again, dear learner. I am your instructor and we are dealing with the course Understanding Competition Law, Theory and Practice. We are in 7th module of this particular course and today we will discuss about the regulation of combination, the procedural aspect, and it will be the last session of this particular module. And in this module, that means what we have discussed, that is about the regulation of combinations. We have discussed the meaning of combination, what transactions comes within the meaning of transaction, when the combination, under the combination, the requirement of the notification is become important, what are the procedure and what are the regulatory measures. And in this context, in today's session, that is the last session of this particular module, we will discuss what we were discussing in last session, the regulation of combination, but today we will focus the procedural aspect of regulation of combination as continued in the Competitions Act 2002, and there are something and like the related regulations we will discuss with the both. So, before going into the detail of today's session, just see the previous lecture. If you remember, we have discussed about the section 6. Section 6, which is about the regulation of combination. In case we have discussed that it regulates the merger, amalgamation, acquisition of share, voting right, assets, or control over an enterprise that meet certain financial threshold outlined in section 5. The core principle is to ensure that such combination do not cause an appreciable adverse effect on competition within the relevant market in India. If a combination is likely to harm competition, it is deemed void under section 6 subclause 1. For example, if you remember, we have already discussed in last session, but just for the remind, suppose there are two major telecommunications company and they plan to merge. They must notify the CCI and CCI will evaluate whether this transaction will adversely impact to the market or not, like it will lead to market dominance, higher price, reduced quality, choice, or prejudice to consumer, or in any case if it is like to causing the appreciable adverse in market, and if so, the merger may be blocked or modified. For that purpose, CCI evaluates such combination under section 20, 29, 30 and 31, and there are some regulation 2001 and other. So today we will discuss this procedural aspect with the help of these statutory provisions and the regulations for the purpose of regulation by the CCI. So let's start with the procedure of inquiry into combination under the Competition Act. The Competition Commission of India follows a detailed procedure to inquire into a combination as outlined in Competition Act 2002 and the Competition Commission of India procedure in regard to the transaction of business relating to combinations regulation 2011, and for you people, here's a comprehensive overview. So we can see it step by step just for the better understanding as a practical aspect what is the procedure to inquire into the matter of the combination by the CCI. So just start with the filing of notice, that is step 1, what we have already discussed in previous session, that it is mandatory to notify the merger if it crosses the threshold limit, and consequences like in the failure what we have already discussed that it may attract penalty under section 43A. So the first step is notice, and the notice is the parties to a combination file a notice with the CCI in case of form 1 and form 2. There are the prescribed form 2 is basically the detailed requirement of such combination which is specified under the regulation 2011. definitely there is a fee for the purpose of the notification, and the notice is accompanied must be the prescribed fee, and the fee may be vary on the type of the combination or the size as per the assets or the turnover. And the requirement of the detail, the notice will definitely disclose all the detail which is important and material fact about the combination, type of combination, about the information, that is personal to professional information, sometime from the parties, the persons who are getting involved in such type of agreement, and about the companies or enterprises or the entity. Now the second step is prima facie establishment in the eyes of CCI. This review is important to inquire into the case of the regulation, and it is under section 29 subclause A. Section 29 subclause A demands that there must be a review. That means the CCI reviews the notice to determine whether the combination is likely to cause an appreciable adverse effect on competition in India. Timeline is the CCI has 13 working days to complete the prima facie review. Approval, the CCI believe that combination does not raise any competition concern. In that case only CCI may approve such combination under section 31 clause 1. Now the third step is show cause notice under section 29 1A. Show cause notice in such case where in prima facie CCI believes that the combination may cause the appreciable adverse impact on competition. In that case, CCI may issue a show cause notice to the concerned parties, and the parties have to respond against such notice within the 30 days, and response will be in the form of, if it is required some additional information, or it is with the proposal to the modification in the proposal earlier which was given in the case of combination, or the party may withdraw the earlier proposal, or in such case withdraw the notice. Now the next step is detailed investigation by the DG, Director General, under section 29 subclause 2. CCI, if prima facie establish that there is a possibility for the appreciable adverse impact on competition by this combination, the CCI may direct to DG for the purpose of investigation. That means if the CCI is not satisfied with the response of the parties against the show cause notice, it may direct to Director General to conduct the detailed investigation in concerned matter. The DG investigation the combination and gathers information from the parties, competitor, the concerned stakeholder and customers too. And after gathering the conclusive reports or the evidences, information, fact, detailing, or anything which is required or which is the material fact for the purpose of detailing the report, after compiling such information in a form of report, the DG will submit its report to CCI for the purpose to the inquire about the if there is a potential impact of appreciable adverse impact or not. Now, after the submission of report, the CCI will consider the report and as well as the response of the parties what he have already under section 31 clause 1. Consideration is the CCI will consider the DG's report as well as the party's response. After getting the reports and analyzing the report as well the analyzing the response of the party, CCI may approve such combination if found there is no potential impact on appreciable adverse impact on, that is, on market. CCI may slightly modify the proposal if he thinks, if the commission thinks fit for the purpose of, if it is prejudice to consumer or prejudice to the economy or to against the market and relevant market, or may blocked. That means CCI is authorized to reject the proposal of combination if it determines that it will cause an appreciable adverse impact on competition. Now the next step is what orders will be given or what orders can be given by the CCI. So there are some specific statutory provisions like section 31, read with the regulations, which authorized CCI to take its decision and issue an order to concerned party regarding the proposal of combination on the basis of the analyzing of the detailed investigation reports submitted by the Director General, or on the basis of response taking the both into the consideration. The CCI may approve the combination under section 31 clause 1 if it determined that it will not any cause harm to the appreciable adverse impact on competition, or CCI may approve the combination with modification under section 31 clause 3 to address the competition concern. CCI may reject the proposed combination under section 31 clause 2 if it determines that it will cause an appreciable adverse impact. And this inquiry process integrate the above provision and rules into a cohesive framework. Notification under section 6 subclause 2 with regulation 5. If you see the regulation, the procedure, the parties file a notice in a form 1 or form 2 within 30 days of triggering the event, that is board approval or agreement execution. The notice includes the detail of combination, market structure and competitive effect. Composite transactions require a single notice, and for that purpose there is regulation 9 subclause 4. So there are 3 steps which become important. That means for the purpose of a summary, for making a summary of the procedural aspect of the inquiry into the matter, if the case is about the proposal of the combination comes before the CCI, CCI may take the inquiry or action to determine if there is appreciable adverse impact or not, for taking the decision of approval or rejection of such proposal. So the whole procedure of the inquiry may be, you may categorize in 3 initial stages. There are 2 forms. In first phase, it may be divided into the 3 category, and again it may be divided into 3 categories. The first is the preliminary review. This is the first phase. Under first phase, CCI may take the preliminary review under section 30, section 29 clause 1 with the help of the statutory regulation 14. CCI scrutinize the notice of completeness within 30 days. A prima facie opinion is formed within 30 days of a valid notice as per the regulation 90. And as per the section 31 clause 1, if the prima facie CCI believes that there is no apprehension to cause any impact adversely on the market in the competition, CCI may approve such proposal of combination. But in case of any suspected appreciable adverse impact on market on competition, CCI may issue a show cause notice. Now, the show cause notice is governed with section 29 clause 1 and regulation 20 of regulation 2011. And in such case, the CCI outline appreciable adverse impact on competition concern like the foreclosure, entry barrier, market dominance and other things. And CCI may issue a notice for the sake of the response from the parties, and parties have to respond within the 30 days by providing the data, information, additional information, any efficiencies or remedies or any additional proposal or modified proposal. In the case of show cause notice, the parties may respond. And on the response, receiving the response, or to inquire into the matter of the regulation, CCI may order to the Director General, and which is governed through section 29(1)(a) with regulation 21. The CCI may involve the DG for complex cases, inquiring a report on market share and concentration, like there are some Harry-Fedel and Hartman index. You may refer to the websites of CCI, and you may refer to the document which has been referred in this material. There are barrier to entry or vertical integration, consumer impact or innovation effect, the report of submitted within the CCI timeline. So, after getting the inquiry completed, the Director General is supposed to submit its report. And now CCI, under the provision of section 29(2) and 3 and the regulation 22, if concern persists, the CCI direct the publication within the 7 days of response or DG's report. Parties publish detail within 10 working days, that is maybe on the websites or the newspaper. Third parties may submit its objection within 15 days, adding their perspective about the market. And if there is a requirement of the any additional information, regulation 23 and the section 29 subclause 4, where the CCI seeks further data within the 15 days of post-objection period, and parties comply to such 15 days, ensuring robust analysis. And after that, CCI may issue an order after final assessment of the case or proposal on the basis of DG's report, response submitted by the parties, objection if any by the third party, and additional information in post objection period. That means on the document available to the record with the CCI, CCI may analyze the fact and take appropriate decision. And for that purpose, we have already discussed, the CCI evaluate the party's response, DG's report, third party objection, additional data, and of course the parameter given under section 20 subclause 4 for the purpose to analyze whether it may be prejudice to consumer or adversely impact on competition in the market or not. And after that, CCI may issue an order under section 31 with regulation 25, and the order will be like approval, rejection or modification. CCI may approve the proposed regulation under section 31 clause 1 if there is no appreciable adverse impact on competition. CCI may directly reject under section 31 clause 2 if it is found or CCI believes that there is a potential harm to the consumer or it may be adversely impact on market in India, or CCI may propose an additional modification or may seeks the modified proposal as the remedy in case of the defective proposal, defective with the perspective to the market economy. There are certain cases like Tata Steel Bhushan Jet ATR 2010. You may refer such cases, and all are available on the website of CCI. So parties may accept the modification within 30 days or propose alternate within 30 days, and non-compliance will lead to the rejection under 31 clause 6. And if in the case the CCI have not passed any order within 150 days, it will be like deemed approval and post order compliance with regulation 16. That means if your order is published respecting confidentiality and the regulation 30 with section 31(12), this ensures timely resolution. So for this, we have one case study regarding the combination. So just see, that is a very important and popular case, and the case is the CCI versus PVR, and the case is like the PVR and DT Cinema combination case, and adjudicated by the Competition Commission of India, and order was issued on May 4th, 2016. The parties who were involved in the case, like the PVR Limited, which is the multiplex, a chain operator in India, engaged in the developing, operating and managing cinema theatre at the time. The PVR has 467 screens across 43 cities in India. And on the other hand, DLF Utilities Limited, which is a subsidiary of DLF Group, engaged in various business including operating DT Cinema, its film exemption, and DT Cinema had 29 existing screens in Delhi, Gurgaon, Chandigarh, and 10 additional screens in the development NCR region and Noida. The proposed combination in that case was in June 2015, PVR announced its intent to acquire DT Cinema film exhibition business comprising 39 screens, that is 29 existing and 10 upcoming, with approximate 9,000 seats for 500 crore on slump sale basis. The acquisition aimed to expand PVR presence in 45 cities with 115 multiplex and over 500 screen. For that purpose, it was notified to the CCI, and PVR filed a notification to CCI on July 8, 2014 under the provision 6(2), and the CCI initiated a review to assess whether this combination have any appreciable adverse impact on market or not. So in this case, CCI adhered on the procedural timeline and started the investigation. That is start on October 9, 2005, CCI issued a show cause notice to the PVR expressing a prima facie opinion that it may harmful or prejudice to the customer or the appreciable adverse impact. In December 11, 2015, the CCI invited a public comment for the purpose of raising objection, if any, by the third party. The review process again extended to 302 days, and exceeding this limit, which was actually only 210 days under the 6(2)(a), and because of the complexity of the issue which need further investigation, and that was rarely, but in that case it was exceeded. And CCI assessed the case and analyzed by the defining the relevant market, assessing the competitive impact on combination, and CCI assessed it by establishment the relevant market on the basis of relevant product and relevant geography market. And the relevant product market as per the CCI, because the case is important, because PVR was arguing for a broader market to see the exhibition of film through theatre, asserting the all theatres serve the same purpose, but CCI noted that multiplex offering distinct advantage over single screen, including a greater choice of film, high ticket price and additional facility. So this argument is not valid of the PVR that the every cinema hall has the same intent. So with this, the relevant product market was defined in the case by the CCI as market for exhibition of film in multiplex theatre and high-end single screen theatre. And from the perspective of geographic market, the CCI observed that the people prefer to watch the film nearby theatre, making geographic proximity. So CCI identified some geographic markets like Gurgaon, Delhi, Northwest, Noida and Chandigarh. And finally, competition concern about the appreciable adverse, CCI assess the potential in the identified relevant market by analyzing the market share level, and key concern include the market dominance in a specific market. CCI added on this particular. And for example, if you see what CCI said, that in South Delhi, the combined entity would control a substantial portion of multiplex and high-end screen theatre, which reduce the competition pressure. But again, in Gurgaon and Noida, the merger would eliminate the DT cinema as the vigorous competitor, potentially leading to the higher ticket price and reduced consumer choice. Again, what the parameters or factor given under section 20 clause 4, CCI also discussed the barrier to the entry and eliminating of vigorous competitor, and on such parameter, CCI is found that there may be appreciable adverse on impact. On this case, PVR's argument was that broad market definition must be taken. There is no exclusivity of distributor, efficiency from the combination, that was the argument of the PVR, the claim of the PVR that this merger would lead to the economic of scale, improve the infrastructure and enhance the consumer experience. And even PVR proposed some behavioral remedy like the price caps, quality commitment and other thing. But CCI analyzed an evaluation on the remedy, both structural remedy and behavioral remedy. CCI evaluated the proposed remedy and rejected the behavioral remedy proposed by the PVR, and by stating that it is non-compete clause concern. The following concern, even PVR amended the clause to reduce the duration from 3 years to limited geographical scope, but CCI issued its final order on May 4th, 2016 under section 31 clause 7 of the Competition Act, subject to some modification, that is divestiture of assets, expansion, freeze, and CCI concluded these modifications would preserve the pre-combination level of competition by ensuring the presence. So you may refer this case as a practical procedure aspect of the CCI, how CCI take action in case of the combination, if any combination took place and it is apprehension that there may be appreciable adverse impact. So the assessment for you people, just suppose the Competition Commission of India is investing a potential combination under section 29 of the Competition Act. Let's say company A, asset of 2000 crore, want to acquire company B with asset 800 crore, and in the same market. Does this acquisition require notification to CCI, and what are the potential next step under section 29, 30 and 31 of the Act? So with this, I am leaving this session for you just to assess yourself. So in next lecture, we will discuss the enforcement mechanism under this Act. So for today, thank you.